Good morning. Let's see everyone in. Okay, good morning. Good morning, everyone, and welcome to our How Not to Drive Your Business to Zero, but actually set yourself up to thrive in the aftermath webinar series, where we have been interviewing experts in their field. Today, our amazing host, Daniel Watson, Director at Vertec IT Services, will be interviewing Carolyn Ranson, Partner at Smith & Partners. Once again, before I hand over, a few important notes. A recorded version of this webinar will be available on our socials. Should you have any questions, please post them in the chat, and all of the questions will be attended to at the end of the interview. And you can also get a list of our upcoming interviews and the dates on our registration page and also our socials. Okay, so over to you, Daniel.
Thank you, Bianca. Hello, hello, hello. Welcome, everybody. Hello, Carolyn. Thank you for agreeing to jump in on this. Now, how do I know you, Carolyn? I know you from, one, our kids went to the same school. Well, that's one thing. But two, you also gave me some extremely great advice when I was dealing with a woman who has now been convicted of 35 counts of fraud. Theft of somebody in I can't even remember the names of the charges, but it was great. It was all 35 charges. And the advice I got from you really gave me the strength to push through on that one. Whereas I'd had advice from others to say, you know what, just drop it. You know, everything's biased against the employer. You're not going to win. So thank you very much for that, Carolyn. There we go. All right, cool. So, so that's a bit about behind that, and because your specialty is employment law, right, at Smith & Partners?
Yes, so it's one of my specialties. I supervise the litigation team. So one of my other specialties is estate litigation as well, and I also dabble in retirement village law. Actually, is a little just to keep that balance between litigation and private client work. So yeah, that's sort of my three main areas of practice.
Right, I can imagine there is actually probably some interesting topics we could delve into there. Maybe a future episode, because I've got clients who are retirement village owners, and
oh right,
yeah, and there's and every family has had drama at some point, and when somebody is passing on and they've got some assets, then and if there's more than one person involved, there's going to be some kind of contention, I imagine. Anyway, so what are we here for? We're here for the topic. We're in a world of interesting times, and lots of people have been having to make some hard decisions about with their staff, right? So, from your perspective as a lawyer, what's the biggest mistake a business owner could have made already, or could make right now when dealing with their staff?
Well, I think the biggest thing for me that I've noticed over the period, when we went into lockdown and everything just happened so fast, and we were, it was within a few days, and although we had a little bit of time prior to that where you could see the writing on the wall, when it actually happened, it happened really quickly. And and the government acted quickly, which was great, by putting together, a number of different, areas of assistance. But what we noticed was that people, business owners, understandably made very quick decisions, and I think a lot of people made the decisions and implemented them without necessarily taking advice on them before doing that, and they might have taken, as particularly, an example is obviously the wage subsidy, where because the wage subsidy talked about revenue, and that eligibility and, the 30% drop in revenue or forecasted drop in revenue, and it talked about those sorts of numbers. I think a lot of people contacted their accountants, which was a really good thing to do. That's what they should have been doing. But then they didn't take legal advice. And so they just went ahead and made changes, made the application. Some of them made it, you know, on the day that those announcements came out and that subsidy was available. They just went ahead and applied. I think a lot of employers, a lot of business owners did that within those first couple of days. And the danger with that, and I think we're going to see that as we come out. We're not seeing it straight away, but we will see it. The danger is that, you know, the law still applies. The government subsidy and the arrangements that the government has put in, the assistance that it's providing, doesn't change the law. So, you know, the Wages Protection Act still applies, the Employment Relations Act still applies, the Privacy Act still applies, and the employment agreement that you've got with your employee is still in place. And so any changes that you make, you have to either have, you know, you've got to have an agreement. You can't unilaterally make changes to any of those in terms of employment without getting agreement from your employee. And in terms of the wage subsidy, the big thing there was the privacy issues, because even if you were continuing to pay 100% and just using that wage subsidy to assist you with that, the very fact that you've made the application, you are obligated to get consent to your employee's private information being given to MSD. So
oh, really? Okay.
So I think, you know, looking ahead, you know, I haven't seen a lot of that come up, but I think it will, because what will happen is that as we come out of this in the weeks ahead, if somebody brings a personal grievance, then their lawyer is going to be looking and saying, okay, so what, you know, tell me, run me through it. What happened? You know, okay, did you give consent to that private information? And it's just going to be used, you know.
You know that feeling when you think you've just realized that you may have just done something really stupid, that sinking feeling in your stomach? I'm wondering if anybody listening to what you're saying right now is having that feeling, going, oh, right. Yeah. So, yeah.
And it's unfortunate because the government acted so quickly, which was great because they needed to provide that comfort to business owners at a very stressful time. But because they acted so quickly, when you looked at what information was there when you made that, in that first week in particular, there wasn't a lot of information that didn't say on there about your employment obligations. And so they made, I don't know if you remember, they made some changes on the 27th, that came on the 27th of March, wasn't it? At 4 o'clock. So there are, the law is different depending on whether or not you applied for the subsidy before 4 o'clock on the 27th of March or after. So that complicates issues because employees, and we've had this already, you know, if they look at what the law says at the moment, it will, and you know, everyone's Googling, you know, things, especially employees, if they think, you know, I'm being hard done by.
Yeah.
what they are finding might actually not apply to them, depending on when their employer applied for that subsidy. But what some of those changes were is making it clearer to the employer when they're making that application exactly what their obligations are, so that they put some of those issues and measures into the declaration, such as the privacy obligations into the declaration. So that's in there now, but it wasn't in there prior to the 4 p.m. on the 27th of March.
Okay, well, let's hope that people are sensible about that. You mind just moving your headphone over here, because the microphone's scraping against your neck. That's better. Cool. We should be much better.
Hopefully I don't shout now, because I can't hear myself.
So there was a couple of things which came up in there, right? So so there was the consent for actually from your employees to provide that information to the MSD. So that could come up as an issue. Is it possible to go back and then just say, hey, look, we did this, get a retros? Oh.
No. Unfortunately, the information has already been given. So,
yep.
You know, it's a little bit too late. And, you know, I mean, in the circumstances, it was a crisis situation. You know, so people are going to be understanding, but the fact remains that those privacy obligations have been breached if you didn't get that consent. So it's a kind of a black and white situation.
Yeah.
You either, you're either in breach or you're not, you know.
Yeah, but realistically though, that's likely to come up perhaps if there is another issue that the employee is going, I don't think anybody's going to, there might be, okay, there's always a couple of people who will go, I don't care, you did something, I'm going to have a go at you, right? And hopefully most people don't have those as employees. But it'll be some other issue that they're going, hang on, I think he applied for this and then he made me redundant 2 days later, you know, so I can see that he's applied for, you know, X number of subsidies and most of us are now redundant. What gives, you know?
Yeah, exactly right. Yeah, so it is. It's going to be one of those things that a lot of employees might not even realise, but it will be something that if they've got a good employment lawyer, you know, as you're sitting down with your client, you're saying, okay, you talk me through the process, because that's what, you know, they should be doing is picking up on all of the deficiencies, not just that, you know, the one that they've come to you about.
Yeah.
And so, I mean, in some of those issues where you're talking about, you know, where employers have gone straight to the 80% as well, without doing a process, without going through a consultation, without getting agreement, without varying the employment agreement. You know, that's where you know, they will be in breach of the Wages Protection Act as well as the Employment Relations Act. And the Wages Protection Act, they've got 6 years to bring a claim on that. So,
I was going to ask that question. I was thinking, is it a 90 days thing or something like that? No. 6 years.
Yeah, because it's wages.
Okay.
So, you know, so you've got 90 days to bring a personal grievance, but when it's your wages that have been affected, there's not that time limit on it. So potentially, you know, you're looking at quite a long period of time that there's that exposure.
Yeah. Ooh. So once it's out of the box, you can't do anything about it. Your best bet is be proactive about it, talk to a lawyer, and act in good faith.
Yeah, absolutely. I think, just, you know, any decisions going forward, because people will now be looking, you know, as we've sort of settled into this, we can see that it's still uncertain, and there's still so many uncertainties, but I think people have got over the shock of that initial, couple of weeks. We've got a new normal, and as we go into level 3 and then into level 2, business owners will be, undertaking strategic reviews of their business. They'll be looking at their revenues, they'll be looking at their cash flows, they'll be starting to make decisions about staff, reducing costs by reducing the salaries and wages costs. And as they look at all the varying ways that they can do that, just to make sure that any decisions that they make, they've taken good advice on, and especially as they go to try and put those decisions into practice and implement them, to make sure that they've ticked all the boxes, so that they're not setting themselves up for an expensive claim. Because that's the other thing that has come probably the last couple of years, 2 or 3 years. Those personal grievance claims that are going through the authority and through the employment court are increasing. The awards are increasing. We've had, I say new, she's not that new now, but we've got chief employment court judge who is pushing up those awards. So,
Right.
So the exposure there is a lot more than it might have been 2 or 3 years ago.
Yeah. And as somebody who's been on the victim side of one of those, it is enormously stressful. And so there's 90 days for that, 6 years for the other thing. Now, one of the things I notice is that, and perhaps people don't realize, is that you can go and look up to see if your employer, in fact, any employer, anybody can look up any other business to see how many people they've claimed that subsidy for. It's just there on a web query, boom, 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 chuck that in there. I don't know. Is it unethical to check out your competitors' searches, things like that? I don't think so, is it? No.
I don't think so. I think a lot of people will have been doing that. I mean, people want to know.
I know, I have. Yeah. It's like,
as you're making those strategic decisions, I think it's it's just part of that due diligence, is to see what your competitors are doing, because that's an important part of how you're going to play things. And we had a really good survey that came out in the last week of, there's been a whole lot of law firms surveyed, and the information that's come out in that has been really useful for us. Just seeing what other firms are doing, how everybody's, what everybody is thinking about, what they're thinking the future is going to hold, what they're doing with their staff, and how they're predicting their revenues are going to be. I think that, that collaboration, if you like, I mean, checking people's wage subsidy applications is probably not classed as collaboration, but I think just learning from what other people are doing in the same space that you're in, it's just one of a number of pieces of information that is really useful to gather together when you're looking at making decisions in an environment like this, which is unprecedented and is changing constantly. Almost, it's been almost daily, we've had these changes come through. So it's really difficult to operate in that environment. And a lot of us have had to come out of our comfort zone to do that. And look at new ways of doing things.
You shouldn't allow yourself to get isolated. That's one of the problems of being a business owner. As a business owner, is that you can't confer with the people that are around you, because it's a different relationship. But there's nothing wrong with actually reaching out to people you might think are your competitors, but realistically, they are the closest thing to your peers, because they're suffering exactly the same problems. I'm continually surprised with how infrequent I actually get into a competitive situation with another IT business in Auckland. You'd think that, because it is quite competitive. I mean, our Google AdWords costs are huge, but realistically, when you're coming down to, if you're dealing with a client to client, it's not a problem. But so I find it odd when people don't, I go to conferences with either IT guys, and there's always a few people who are very reticent to say anything. It's like, oh, I don't want to give away our secret sauce. There's no secret sauce. Everybody's, nobody's business model is unique. But what you will find is that actually most people have got very similar problems, and it's very, it helps settle things down for you and calms things down if you do find somebody who's having a similar issue. Talk to them about it, find out what they've done. It's problem shared, problem halved, and maybe you'll find out something new that you didn't know before. So I wanted to get into some more details things, and actually we're getting some questions coming up, which is cool. So maybe we jump into, hang on, let's see if, now I've got some specific ones, right? One of them was, can you actually make your staff take annual leave, or leave without pay for that matter?
Yeah, so if you're talking about annual leave, you can agree. So if both parties agree, then obviously then that can happen. If the employee doesn't agree, so if you propose that and they don't agree to do that, and we see a lot of businesses saying, okay, we're going to reduce, say, hours to 4 days a week, and you take the 5th day as annual leave, for example. If the employee says, well, no, I don't want to do that, then an employer can make an employee take the annual leave if they give them 14 days notice. Of course, it will depend on what is in the individual employment agreement, but generally speaking, if they give 14 days notice, especially under these circumstances, then they can do that. But I mean, the best position to be in is to get your employee on side to explain to them why you're proposing that, why you're asking them to do that. And we're finding most people are, they understand, and they can, once it's explained to them. And, I think those face-to-face Zoom meetings in this environment are really important, rather than just, sending out a blanket email or, a letter to people. Getting your employee on side by having that face-to-face communication, even though it is, it does have to be via remote.
Yeah, I mean, realistically, they need to understand that sometimes it's not like you're just trying to put more dollars in your pocket. It's a case of, you need the company to survive so that we all have jobs in 3 months' time, right? Because you can keep going paying everybody out right now, and then you're going to have a massive cash flow divot, which means that you no longer can operate. You can't order in the kit, you can't pay your suppliers, and then what then? Oh, well, fold. No.
Yeah, and I think as business owners and employers, you can't assume that your employees understand that,
No.
Because, unless they've had that experience themselves, it might not be something that they have considered. And you need to have those talks with them to explain it.
Yeah, often they just see the amount of money that you're charging them out for, or something like that, and they assume that you're Mr. Moneybags. But business is different than that. There's a whole lot more to it, and if it was easy, everybody would be doing it. Now, if you claimed the wage subsidy and things then still like it, you realize that this is not, we even with this, we can't make it. We're going to have to radically change our business model. This is going to mean redundancy for some or all. Are you going to be in trouble for going down that pathway, having taken the wage subsidy?
So some of it will depend on when you applied for the subsidy, which is, it's that 4 o'clock on Friday, the 27th of March. That's that crossover, the sort of cut off when the law changed slightly. So
to be more tighter?
So after that time, if you applied for the subsidy, then you had to declare that you would retain all staff that were included in that subsidy application for the full 12-week period. And so and you do have an obligation to, if anything changes, to notify MSD and potentially repay, you'd be liable to repay back the subsidy if you were to make people redundant. But the idea is that you shouldn't be making anybody redundant in that 12-week period if you have, particularly if you've applied after 4 p.m. on the 27th of March.
Right. So it's game out those moves carefully, because it's just constraints, right? It's not necessarily a no. It's a step carefully, because
and if you applied before, so it will depend on when you applied, and it will also depend on what's in your employment agreement with your employee, and the employment law still applies. So that's the key thing, is that all of those obligations still apply. So just because it's a crisis situation, you've still got to tick all those boxes. So even if it was before 4 p.m. on the 27th, you've still got to go through the proper process and abide by the law and act in good faith and all of those sorts of things.
Okay, let's take a question from the chat, from Wayne. Do you recommend including a reference to the government wage subsidy in employees' payslips?
I think there are some of the programs that people use, the wage payroll systems, have the ability to do that on people's pay slips. And I think it's just a matter of being transparent with people. I don't think you necessarily have to do that if your payroll system, it's a bit difficult to actually make that happen. But I think you should be telling your employees that you're using the wage subsidy. I mean, you will have, in a perfect world, you will have told them before you applied, because you had to get their consent and their privacy consent. So they will know that you are using that. But I think, just to be crystal clear, I think it would be good practice, if you can, to include that on the payslip, so that there's no misunderstanding, and everybody knows what's happening. And it's good for your records as well, and that's the other thing, is to keep really good records of what you're doing with that wage subsidy, because you've got to use it for wages for the people that you have listed in that application. So if, for example, someone resigned during that 12-week period, then you'd have to notify the government, but you wouldn't necessarily have to pay back that difference in the subsidy, but you would have to apply that difference to wages to people who have been named in that application. So you need to keep really
terrible.
good records.
Yeah.
And you need to be applying it, you know, it's for the purpose of keeping people employed.
And I know that the government is planning on auditing this stuff, because one of our previous guests from BDO, they said they've picked up the contract to do that auditing.
Right.
So
Excellent.
Yeah. It kind of seemed like it was a lolly scramble at the beginning. It was like, seriously, this is too easy. The money's like, boom, there, way, great stuff. But that you have given them information that does make it very easy to do matching on, you know, if this IRD number is turning up in 2 different companies, then, what's going on there? That would raise a question. So there's another couple of really good questions in here, right? How do you change and manage an employment agreement now, not knowing what's going to happen after the lockdown? Surely it has to change with the new normal. And I guess that links in with another question in there, which is, how would this pandemic change future employment agreements? So looking forward.
So existing agreements, you know, as usual, you know, if you're making any change to your employment arrangement or your employment agreement, then it's a variation, and that cannot be done unilaterally. You've got to have agreement. If you don't have an agreement, if the employee doesn't agree, then you need to go through a mini restructuring process, so that, you know, you've got a business case, you've got a proposal, you know, you go through that sort of a process. So you can't just make changes to their existing terms of employment and their existing employment agreement. That's really clear, because that's still in place, the law applies. And yes, it might mean that the process might be able to be a shorter period of time because of, you know, the situation that a lot of businesses are in, where, you know, it's an urgent situation, but the process still has to happen. So, and I think it's important that any agreed changes or any changes that come out of any restructuring process is documented by way of a variation agreement, so that it's really clear how the employment agreement has been varied and it's signed off, and and, you know, you've got those records in place, and you've got records of the process that you've undertaken. So it's all been in writing, and you know, they've had opportunity to take legal advice, and that, you know, you've ticked off all those you know, those items. In terms of going forward, I think you know, someone who drafts these agreements, I think lawyers will be turning their minds to this sort of situation. And, you know, I know you've talked on your series on the tenancy, you know, landlord-tenants, commercial landlord-tenant.
Oh, you've gone muted for some reason. Hang on.
Sorry, my phone just rang. 27.5 of the Auckland District Law Society standard lease, which came in as a result of the Christchurch earthquakes. And, you know, a lot of us lawyers now are you know, thanking those lawyers who, at the time, as they came out of that, and as those you know, as those new versions were coming through the Law Society, you know, had that clause put in, because that's really helped a lot of tenants. And similarly, in this situation, what employment lawyers are talking about at the moment is, you know, the issue of if there is no work, so if an employee cannot work from home, and if there's no work for them to do, they cannot work from home. So and the employer can't provide them with work, then is there an obligation to pay them at all? And there's a lot of differing opinions on that. You know, it's almost like, has the employment agreement been frustrated from both sides? You know, neither party can fulfill their obligations under the employment agreement.
Yeah.
And so I can see that it's going to be really useful going forward to actually address that in your employment contracts, so that you have a clause that covers this situation, so that if there's an emergency situation like this, and it might be a pandemic, but it might be, you know, an earthquake or a, you know, whatever it might be, that it's provided for in the contract. You know what your obligations and your rights are. Both parties know, and it's covered off, because it's not something that has been anticipated in most employment agreements in New Zealand. And that might be a little bit different down in Christchurch, but because of the earthquake. But most of the employment agreements we see don't refer to that sort of a
no, that's right.
situation.
I mean, you know, with cybersecurity, it's a case of you're always trying to keep up with what's happening, but generally the next threat comes out of the blue from a direction that you could not have anticipated, because there'd been no evidence of anything, attacks like that. So when you do that, you just go, right, well, now we have to paper over that that particular angle and put in a threat response there, and you just keep on going, and you keep adding on these layers of security, because you can't. It just gets bigger and bigger and bigger. Okay, we've got another question from Daniel Silva. Will the strictures of current employment law survive 25 to 30% unemployment?
So what he's talking about is, I'm not quite sure what the question is. Is he saying that, I mean, employment law in New Zealand is, you know, it's probably not controversial to say that it does favour the employee, and I guess that might be what he's talking about there. I think that overnight we've gone from a situation in New Zealand where there's been high employment, almost full employment. It's been an employee's market, if you like. It's been really hard across the board to get staff, never mind good staff. The employee has definitely been in the driving seat, and in a lot of cases I've seen over the last few years, you tend to see the tail wagging the dog, because employers, you know, they'll say to me, like, they're not very good and they're a pain in the neck, but I can't afford to, you know, cut them loose or even performance manage them, because I can't afford to lose them, because I can't get anybody to replace them, and I could get someone worse, you know. So that's been a real issue for a lot of business owners, is that staffing issue. And what we're going to see if we do go into, I mean, hopefully we're not going to go into over 20%, but, you know, that's part of, you know, the predictions. But either way, I mean, there is going to be a big change in those dynamics. And so, you know, in terms of from a business perspective, you've got to look at the benefits that are going to come out of this. And it's, you know, it's an awful social cost in terms of unemployment, and it's a cost to the taxpayer, and there's all those sorts of things. From an employer's point of view, there's obviously going to be benefits in terms of having a bigger pool to employ from, and having a bit more control over that whole process.
Yeah.
So I think that will be a big change.
I think that is going to be the silver lining from an employment perspective, rather an employer's perspective about employment, is that there was 40,000 New Zealanders came home in a very short space of time, and I think it's a truism to say that the people who do travel, leave the country and then come back, bring back with them, they're the ones that've got the initiative to actually get themselves off and make it in a completely different marketplace, and then they come back with generally much better experience and bigger markets, and bring that knowledge back to New Zealand. So there's actually going to be, I think there's going to be a real opportunity to pick up some really excellent talent that can help drive, because that's what every business is. The biggest problem is, once you've sold sales and marketing, it's like, okay, how do we service these clients? You got to have good people in the right spots, and I think that's the optimistic angle that I'm pushing for people to look at, is that this is the point where you can make some hard decisions and then set yourself up to really shine. So but employment law is employment law, and it's not really going to change, I think. You just might have a different employment agreement that you put in front of the new people, right?
I think in terms of the law, it's not going to change, especially under the current government. I think that is there's going to be no changes in that respect that are going to benefit employers. But I think when you're negotiating with your employees at the front end, you are going to have more leeway and more ability to put in provisions that in the past they may, an employer might not have wanted to put in, because the fear that the employee would say, oh no, that agreement's too onerous, I'm going to go with the other one, or one of the other 5 I've been offered, And so, there are all those issues, some of them are, one that springs to mind is the KiwiSaver issue, because, is that included in, most employment agreements that we see, the KiwiSaver is on top of the salary portion, if you like, the wages portion, whereas, you could have that as, included in the salary. Most people don't, but that could be a change that people do, and employees will be more likely to accept that, because, if everybody's doing it, and if there's more competition for roles, then that's one example of where an employment agreement might change as a result.
Very good. Okay, so we've got to it's 44 past. I think we should probably tie it up there. We don't want to steal too much of people's valuable day, and yours, of course. Okay, so if anybody has any questions that have been sparked by this in their own particular situations, and they need to delve into it more with you, Carolyn, how can they get hold of you?
So I am I'm on LinkedIn, and I will this will be going up, and I'll link it into my LinkedIn account.
Very good.
But yeah, I mean, just an email or a phone call, or just a question, a message. Happy because I think that's one of the points you made about that collegiality and the collaboration. I think that is another benefit that's come out of this, is that people are more inclined to give up their time and share their knowledge with people. And it's brought us all together. We're all in this together. So
yep.
Yeah.
There's a lot worse places to be right now.
Absolutely.
All right, very good. Thank you very much, Carolyn. We'll just bring in Bianca. Bianca, do you want to come and tell us about what's the next in this episode series?
Okay, on the 28th, we have Alex Smith, CEO at Brittenden Smith. So yeah, on the 28th, Tuesday.
Very good. And I think he's going to be talking on the topic of coaching remote working teams. That's what he's been doing a bunch of recently. Apparently he's been busier than ever. Excellent. Okay. Thank you very much, Carolyn. Thank you all for attending. Excellent. Okay. Have a great day. Cheers.
Thank you.